time till 27/10/2025 to file a rejoinder to the affidavit filed by the respondent number 6 herein. Prayer accepted. Registry to list this matter again on 28/10/2025.
I would like on for a criminal revision motion regard.
My senior Nigazi. Give mention memo, she will give the dates. I can read it.
The mention is for
All along.
I need to mention item. The matter is listed on the top lordship. Otherwise, also we have facing some difficulties. We have find whether will be pursuing the matter or not, lordship. Some
You will
difficult.
have to pursue the matter. It's with regard to 2 checks.
Lordship. Otherwise, kindly only 4 days time may be granted and matter may fixed in next week, lordship. Any date,
You are
lordship.
appearing. Mr.
Iguhai, lordship.
You're there.
Lordship, I am, but
We'll help you.
already
You
from-
try to argue. He is not there,
that's why, lordship.
but you will have to now step into that shoes. Then only she will also love it.
Lordship,
Ah.
lordship, kindly accommodate only 4
Uh,
days.
Mr. P. Gohai, learned counsel for the petitioner, submits that the arguing counsel is no longer having passed away. Alternative arrangements could not be made in the alternative arrangement is to be made for alternative arrangement is to be made in the matter. Accordingly, he prays that the matter be taken up on 28/10/2025 as a top of the list matter. Prayer accepted. Registry to list this matter again on 28/10/2025 as top of the list matter. 16.
Yes.
This matter we will not. That matter I had to because the arguing counsel is no longer in this world. Mr. Kamar is not here. Then who is the person engaging Mr. Kamar? Serious allegation, ACS officer. We'll see. Try to.
File lordship without the file.
Ma'am, if you had that problem, you should have put in a note. Circulated a note that you're not doing it.
I did not have.
Have you taken the consent of the other side? No. Then there are private respondents here. Complainant is on record. Let the matter be called up. We'll see. Ms. Gain, you need not wait. We'll pass the orders after the, we'll try to pass the orders after the list is over.
Yeah, please, your lordship. My lord, item number 15, my lord. My lord, in this matter, my lord, since last half an year, my lord, we are unable to contact our client, my
You
lord.
need not. We 366A not proved, 365 proved.
Yes, my
Then?
lord. And so far whether he is alive or not.
No,
it is
that's
also not-
for your headache. You have time till the matter is
Lord,
called up.
if your lordship.
We'll not adjourn. Sorry,
If
not
lordship-
for that ground.
1 week, my lord,
No,
I will write.
not
the
even
letter.
a day, not even an hour.
Single day, my lord.
No, I'm sorry.
Wait, please.
Hmm.
I'm very sorry, my lord, could not, my lord, read it out, the evidences, my lord.
Can't help it. We gave you enough time.
Lordship has given enough time, but I have also tried my best.
You
But
forget it,
could not
you
read out.
now read.
The prosecution will help us, my lord, reading the evidence, my lord, that will help. the Proper disclosure of the matter. And so far, my lord, only evidence cross part of the, my lord, W1 can be read, my lord. I
Can't help it, Mr. Soikia, you had it from 2014. Then If you had not done it for the last 11 years, we can't help you. What is your ground? Any ground here? See, your one of the ground was that you were not identified by the
By the prosecutor.
She cannot, because her statement is that she did not know you, but she got the information from her nephew. And the nephew has identified you. He was along with her. One. Two, story with regard to two bridges. How does it matter? How does it matter? Because those are something after a long lapse of time, maybe it just went away. But the act of the nephew being hit from the backside, established, she being dragged away to the forest by holding her hair, established from the evidence of the nephew, and the girl has categorically stated what the act was done upon her. Right? What more is required?
I can read the cross part of the
But 11 years, if you could not rectify, how can I permit you to do it today? And that I permitted you, Mr. Sir.
The Lordship has permitted, I have also gone through, my lord.
Then we will have to be, I can't help it. It's your appeal. You have to take all steps, not me. It's not my requirement. You argue. Tell me what it is.
Cross part, my lord, I can read the PW1, my lord. Only the cross part, my lord. I read the cross. PW1, the prosecuted, my lord. That does not inspire, my lord. There is delay, firstly, my lord. May I read the cross, my lord? PW1. On our piece, there was delay in filing the Ezahar from first statement. মই সহি কৰাৰ আগতে এজাহাৰ পঢ়িছিলো। ঘটনাৰ আগতে আসামী দুজনক চিনি পোৱা নাছিলো। ঘটনাস্থলীত দুখন দলং আছে, এখন নতুন আনখন পুৰণা। এন্ধাৰত কোনখন দলঙত ঘটনা হৈছিল এই কথা মই এজাহাৰ পুলিচৰ ওচৰত দিয়া জবানবন্দীত উল্লেখ কৰা নাই। মই যদি গুৱাহাটীত কাম কৰোঁ, ঘটনাৰ দিনা মই ঘৰৰ পৰা ৰাগ চাব আহিছিল। He was a local resident of that area.
He was not. That's the evidence. Then?
He was, as per her cross-examination, she was a local man. ঘটনাস্থলীত ৰাস্তাৰ ৰাসৰ কাৰণে গাঁৱৰ মানুহ ঘটনাৰ সময়ত অহা যোৱা কৰি আছিল। ঘটনাস্থলীত পোহৰৰ কোনো ব্যৱস্থা নাই। গজেনক মাৰা দেখি মই চিঞৰ বাখৰ কৰিছিলো। সেইবিলাক কাষৰ মানুহে শুনিছিলে। সিহঁতে যিটো অবনি cannot read, my lord. সিহঁতে ঘটনাস্থলীত আমাক পোৱা নাই। Those people came, my lord, they could not find them in the place of occurrence, my lord. ঘটনাৰ সময়ত মই আসামী বিলাকক চিনি পোৱা নাছিলো। গজেনে চিনি পাইছিলো। গজেনৰ পৰাই বাকী বিলাকৰ নাম
Gajen is the nephew.
is the nephew। জানিব পাৰো। ঘটনাৰ স্থলীৰ কাষত দলংখনৰ পূবফালে মানুহৰ ঘৰ আৰু বাগান বনোৱা ঘৰ আছে। Thereafter the sentence I cannot read, my lord.
How did you prepare this appeal? In air or after perusing the statements? Naturally, presumption is that you have perused the records and then prepared the appeal. So that point will not lie.
Court can read, my lord. I have nothing to say, my lord. My lord, they can read, my lord.
Soikia, this is your appeal. You have to take me. You have to take
That's
me
true.
to the inconsistencies. And then we will consider. If you are not in a position to argue the inconsistencies after 11 years, on this point, we are not adjourning.
Lordship may directly, my lord, to make a prepare.
We will not. After 11 years, we are not going to do that. I'm sorry.
And the medical, my lord, record also does not support the case of the prosecution, my lord.
That
That is in English, my lord, I can read.
that we have read, only bleeding is there. No, nothing, no assault, nothing is there.
It does not, Dr.
But
Opine, my lord.
that is not required. She's around 26, 27 years old girl.
Kindly peruse the, my lord, PW4, my lord. On 22/11/2013, I was serving as senior medical. On the day I examined so and so. Connection with Mongolde PS case number. I do not find any injury over the private parts of the victim. Same day, my lord, examination was made, but there is no injury.
Next day.
Next day, my lord, next day.
Maybe she has taken a bath or something. Nothing is
No
brought on.
further motives was seen. Report, no comment could be given regarding rape, my lord. Please. As the victim was having bleeding so and so, admit separate word of Mongol, this edit report may be collected from.
Mr. P.J. Soikia, learned counsel for the petition, submits that he is handicapped in arguing the matter inasmuch as the depositions recorded by the learned trial court of the witnesses are not eligible, are not legible. Accordingly, he submits that he would prepare he would translate the depositions into English and place the same before this court. For so, prayer accepted, registry to list this matter again on 31/10/2025 for further hearing. No further adjournment shall be granted in the matter.
I'm trying hard, my lord.
Mr. Soikia, I'm sorry, this ground cannot be taken after
I'm
11
not
years.
taking that ground, my lord.
You are taking.
Not taking.
You are not being able to read. What does it mean? 11 years these materials were with you. Then you have not taken any steps to rectify.
I'll-
Last chance, Mr. Soikia, we have
31
just
days.
given. Last chance. 31st.
The time being.
Item number 10. You are appearing for? Or Mr. A. Kundu? Okay.
My lord, I have control.
What is there?
My lord, there is only deer meat, my lord.
But where is the connection? Where is that deer meat proved that it is deer meat? Where is the
Yes, my lord,
scientific report?
Yes.
To draw a presumption under 57, you must
Though
have.
it was sent, some parts sent to the FSL.
No, nothing is there. No report of
Yes,
FSL is there.
report, there is no report, but in his, my lord,
So we'll have to allow him. Okay, let us hear Mr. Kundu.
May I please, Your Lordship? Here, my senior will lead in this matter. For Your Lordship, time, Your Lordship. This is an appeal, Your Lordship, 374, Lordship. Conviction under 302, part 302, sorry, 304, part 2 under Your Lordship.
Ms. Begum, have you gone through the?
Lordship, I have gone to, there are two dying declaration, Lordship. 4 and 5,
We will come to the dying declaration.
4 and 5, Lord.
We'll come to
PW,
the dying declaration.
Lordship,
Incident took place.
Lordship,
Somehow it reached the police through the
Right.
public.
Lordship, Lordship.
The evidence is that the accused and the victim were both taken to the police station, Guizan outpost. Once they reached there, they were there. It is thereafter that the brother comes in. Right? And the 4 and 5 are the persons before whom he made we can call it a dying declaration because thereafter he died.
Lordship.
Now, if he was there in a condition to speak, why was his deposition not recorded? Why was he not examined by the police?
IO have said, Lordship, have said that the GD entry was recorded by after the deceased, I was injured by the,
Where is that?
that is PW7, Lordship,
PW7.
PW7.
Very
After that, GD entry was made, Lordship.
perfunctory mannerly there.
Will also support, Lordship.
No, medical postmortem report. You have not examined the person who had treated him when he was alive.
Lordship.
That is not being examined.
That is not bad.
PW7, what does he say?
Lordship, he said that one Ashok Bahar informed in the police outpost that the accused hit him on his head. Then he made the GD entry.
Force part, Your Lordship. I had made the GD entry at not submitted that a GD entry in this case, Your Lordship. Force part, Your Lordship.
No, I wanted this only to satisfy myself that the victim was in a position to speak.
He was.
He was.
He was. So then how can we deny how can you ignore the dying declaration as by 4 and 5?
Lordship, dying declaration. 4 and 5, Your Lordship. 4 and 5 are interested witness, Your Lordship.
Maybe. Have you dislodged their evidence? You have not dislodged their evidence. How can we ignore that evidence? That is very categorical.
Dying declaration must be corroborative, Your Lordship.
Okay, and that is also clear from the FIR
Lordship,
that was lodged.
yes, Lordship. But Lordship, by independent, some independent witnesses are there, Lordship.
A dying declaration may not be before it. Maybe it is before the brother and one PW4 is Angad Biswas. Angad Biswas is not related. He is known.
He was friend of his brother, Your Lordship. He
Maybe, but
took
it is
Friend of the
that-
brother. How can that what is your cross of PW4? You can read the chief. দাদাক ইতিমধ্যে মানুহে গুইজান আৰক্ষী চকীলৈ লৈ যোৱা বোলে গম পাই মই তালৈ যাওঁ। দাদাক মই গুইজান আৰক্ষীত চকীত দেখা পাওঁ। মই দাদাক ঘটনাৰ বিষয়ে সোধাত দিগেন মাতুলেৰে মূৰত মাৰিলে বুলি কয়। আৰক্ষী চকীত আছামী দিগেনক দেখিছিলো। দাদাক চিকিৎসাৰ বাবে তিনচুকীয়া চিভিল হস্পিটেললৈ অনা হয়। Right? So this is the statement. Now come to the cross. My compound so and so, so and so, so and so. The more important thing is 1, 2, 3, 4 lines from bottom. 5. On getting the information, I came out of my house and met my elder brother in Guizan police outpost. At the time, my brother was sitting on a bench in the veranda. I was taken to civil hospital by the police along with my brother, and from there, so and so. Right? And then see the evidence of PW5. 1, 2, 3, 4, 5, 6, 7 lines. অশোকক ঘটনাৰ বিষয়ে সোধাত আছামী দিগেনে তাক মূৰত মাতুলেৰে মাৰা বুলি কয়। Now you come to the cross. Reiterated. He took it out again. A first paragraph, 2 lines from bottom. I had asked Ashok as to what had happened, and he told me that Digen had assaulted him on his head with a hammer. This is in cross. Right? What is the punishment? Three years. So Mr. Monto, you want Mr. Monto to argue this? matter?
Lordship, he. Next week, any date, Lordship?
Hmm?
Next week?
No, no adjournment.
Yeah, Your Lordship, on it. Version.
You satisfy me. Come on, what should I look at? Which is the provision you want me to look at?
He will argue this.
132.1.
Yes, 131.
Oh, come on. No, not 132. This is dying declaration is
130, the 131,
1.
Your Lordship, evidence.
131, sorry.
English.
Yes. Yes, what is that you want me to go through?
Probably that's. Lordship, at 2, Your Lordship.
Okay.
Lordship.
Before one. Can't help it. Others from tomorrow onwards will come, we'll wait. If you don't, 12:30.
12:30.
12 o'clock.
If he is having lost.
Otherwise you will do. You are enough for this code.
Lordship, regarding dying declaration, Lordship, I have some citation, Lordship.
Give me.
Prior to starting this aspect, right, there are 6 aspects which the Lordship has to see. Part is that, my Lord.
You are appearing in item number?
Item number 12, my Lord. I'm in 12, my learned sister colleague is in 30.
Huh?
13 appellant is
Expired. Okay, forget 13. Now we have only 12.
What is there to that?
Yeah, okay, fine.
Self-evaluation.
Okay. We'll accept that.
Now, my lord, first part your lordship has to see. Here in this case, my lord, there was not in conformity with the evidence.
We'll come to this, Mr. Tiwari. We'll go to the facts. This court, it's that old. It's okay. It's an accepted position, Mr. Bachchaji. This court is that old, not the AI chip, the old 786. Let us see what the story of the prosecution is. Two accounts. One cash credit account here, another current account in Calcutta.
No, my lord, all the accounts same, of its same party. Mr.
Oh, two accounts
Yes, my lord.
in two branches, one in Kolkata, one here. And you were enjoying that benefit. All of a sudden, you submit checks of 25 lakhs, right? 25 lakhs of that Calcutta account here. And you claim an advance against that of 30 lakhs. First round rejected, right? First round it was not given.
No, my lord,
Subsequently,
this
it was
is not
enhanced.
there. The rejection is not there. My checks were returned to me and I was given
No,
an overdraft.
we are
facility.
coming to that, mister. We are coming to that. Slowly, slowly. Then the entire episode starts with the enhancement of your
Cash credit limit.
cash credit limit. The basis is this 25 lakhs check, right? The approval is not given by the authorities.
I'll show that. Is there.
PW, the journal managers exhibit 19, not given. Then CL Burua and the branch manager, who is no longer in this world, Lanke, they give you 30 plus 2 lakh 500, right? This comes to your account. Two checks are issued and the amount is utilized, right? Now it reveals that you don't have any balance in that account.
Balance was there 42,000.
42,000 only, but not 25 lakhs. Then PW6 statement is PW6 or PW5 statement is there. He goes to the branch, receives the check after signature in the ledger. Ledger is proved. He comes and gives it to you. You thereafter don't deposit these checks in the original account, right? 120B against CL Borua established. 420 against you established. Now tell me, what should we do?
First, my lord would kindly see Nikhil Merchant judgment. Because, my lord, at para 10 of the judgment, first part and the DW1, they say during the pendency of the proceeding, there was a compromise. And I have paid the entire amount to the bank. Bank compromised. But since it was from the CBI side, the case was from the CBI side, for that only it was not. My lord would kindly come to
Now show me the compromise first.
first, my lord, page 10 of the judgment, my lord. I'll just show from page 10 because it was reflected in the judgment also. Page 10, my lord, third paragraph. According to the learned defense counsel, whatever accused CL Borua had done in allowing
Para 10, page 10.
page 10, my lord, of the appeal, my lord. The judgment, internal page 4 of the judgment, my lord. Internal page 4 of the judgment. Third para, my lord. According to the learned defense counsel, whatever accused CL Borua had done in allowing the overdraft facility of rupees 30 lakhs had been procedural irregularities in the transaction done for the purpose of promoting the business of the bank. And since, according to the learned defense counsel, the matter ended in compromise between the bank and Raj Marketing and the company having cleared all its liability to the bank. Now, my lord, would kindly see the DW1, my lord. DW1, my lord. My lord, in the record, his name is, my lord. DW1, my lord. Is, my lord, Amrit Goswami. DW1. My lord, 106 in the records, my lord. 106 in the records. 106, my lord.
Hmm.
Amrit Goswami.
Hmm.
Now, my lord, would kindly see first paragraph in the chief. I have appeared before this court on receipt of the summons. I have been serving the UCO Bank Jorhat branch since 1983 as clerk cum cashier. Thereafter, I was transferred to so-and-so branch in the year 1987. Thereafter, I have been transferred to various places. Presently, I have been posted in my present capacity at Jorhat. I know that the subject matter of the case with Raj Marketing Company and its sister concern, Messrs. Raj and Company, as well as Mr. Mool Raj Cottage Industries, have been settled amicably with the Jorhat Bank of UCO Bank under the terms and conditions settlement of dues dated 27/3/2010. Exhibit A is the said terms and condition of the settlement of dues dated so and so, bearing reference number so and so are the signature of the bank manager. And there, next parameter, thereafter, no due certificate dated so and so was issued to the aforesaid company after receiving the full payment of the settlement amount. So, my lord, I am relying on Nikhil Merchant judgment of the Honorable Supreme Court, my lord. For a moment, my lord. On the very same ground, my lord. Nikhil Merchant. My lord,
Give me a
internal.
minute, give me a minute.
My lord, cross part also at internal page 3, my lord, he admits that part, my lord. Now, Nikhil judgment is very, on this very same line, my lord. In the cost title, your lordship would find at the very first page, my lord, company who has, of which the appellant was managing that was granted financial assistance by the Andhra Bank. Since the company defaulted in repayment of the loan, the bank filed a suit for recovery against the company and the appellant. Besides, the bank also made a criminal complaint pursuant to a charge sheet was filed by the CBI against the company, the appellant, and 3 other officers of the Andhra for commission of offense punishable.
This decision is following B.S. Joshi's decision, quashing
Correct, correct. Correct.
482
Correct,
power.
correct. 120B read with 420, 467, 468, and 471 of the so Prevention Corruption Act, my lord. Charge indicated that all the accused conspired in fraudulently diverting the funds of the bank. The suit was, however, compromised. And clause 11, the consent terms stipulated that the parties withdraw all allegations and counter against each other, consider the appellant files on. Here in the case also, my lord, overdrawal was given to the company, my lord. And my lord, there were irregularities.
Where is the exhibit A?
My lord, exhibits were never given to me, my lord, as an amicus, my lord. So, my lord, I could not go through the exhibits, my lord. Whether 21 to 23 are relevant, my lord.
Because I found somewhere that the settlement is subject to the, without prejudice to the CBI case.
I am placing this because, my lord, the IO, when he examined himself, my lord, first part is that he initially said in the chief that on a source information, we filed this case. Thereafter, in the cross, my lord, he says that
Exhibit 5.
the source was never informed before the court. So, my lord, the complainant is nowhere there then.
Yes. ये तो बोलना ही blame. Mr. Tiwari, you go through this
Because why
exhibit file. Hmm?
that one? But my lord, para 21 specifically states in the Nikhil judgment, my lord, the basic intention of the accused in this case appears to have been to misrepresent the financial status of the company. Messrs. So and so
That
company
is
in
a
order
bit-
to avail credit.
That is a little bit different.
My lord, because why I'm making this submission, my lord, 420, my lord, the complainant is otherwise the bank only. Now, my lord, if my matter.
No, I
is-
wanted to see whether the settlement
Yes, my lord.
pertains to the same very transactions. Hmm. And that was reiterated in 2013.
My lord would appreciate one part in the cross part of the DW1, my lord.
Hmm.
My lord, he has stated that all the accounts, that is why, my lord, internal page 3 I was trying to show before your lordship, my lord, the DW1.
Hmm.
Although in exhibit A, B, C, the account number of individual companies mentioned therein are not stated. Exhibit A, B, C, yet the settlement of dues and terms and condition wide exhibit D.
Probably.
And in the no due certificate wide exhibit D and exhibit C relates to all accounts of the said companies mentioned with Rico Bank.
Mr. Tiwari, you just go through the statements. Can we take it up at 2? 2 o'clock, madam? Any problem?
I'm obliged, George.
Madam, you also, if required, you can go through the records and then make your submissions. 12, 13 to time. 13, we will close it when we close 12. Together we'll close it.
Please, your lordship, my lord. Petitioner's conviction period has already over, my lord.
Yeah, no stay here.
Here, my lord. So I am not pressing at this. I have also not contact with them, my lord.
Robbery clearly proved. More than 5, aiding or abetting. It's there. And 397 also brought in because they were carrying weapons. And both the victims have stated the names of at least 3 who have been prosecuted. 1 passed away.
During TI, my lord.
Mr.
I alone.
I Alam, learned counsel for the appellant, submits that the appellants herein have already undergone the sentence, and accordingly he desires not to press the matter appeal any further. Accordingly, the present appeal stands dismissed on withdrawal.
Obliged, my lord.
Fifteen. Yes.
My lord, conviction,
evidence to support. Age of the victim, she admittedly is a minor.
minor.
Your 313, your admission that you took the girl along with you and the girl was recovered in your maternal uncle's house. It's your own evidence. What more is required?
My lord, so far the age is concerned, my lord. Here in this case, my lord, the medical opinion has given the person.
The doctor deposing disputed,
Yes, my lord, that is
Fine.
disputed, my lord.
but
Yeah.
there is no material to show that she is above 18.
My lord, so far the medical report, but the person who has examined the victim girl, my
No,
lord.
so the evidence that is there, you have not disputed that also.
Yes.
My lord.
You have not disputed the age. You have accepted that.
My lord, in the cross-examination, my lord, I have disputed that the age of the victim girl is above the 18 years, my
That
lord.
is just a question, but you have not led any evidence to
But
that.
so far the principle of the law is concerned, my lord, that if the.
We are satisfied that the girl is below 18 from the material. She was in a 164, she said she's around 12 years.
12 years.
And when she deposed, it was around 14 years. So, plus the father's, mother's evidence and the doctor's opinion, that cannot be conclusive.
My respectable submission.
Because she said that the fusing of the bones have not taken place.
My respectable submission before your lordship, my lord,
Hmm.
that when the two opinions are come out, my lord, from the single document, my lord, then the favorable to the accused person has to be accepted, my lord. If that be so, my lord, if the 16 to 18.
What happened to the girl?
My lord, say as per the instruction, my lord, I have got the instruction 3 years back, my lord, from my client, my lord. Now I am not able to contact with my client. She already married with some other boy, my lord. And I have also married with some other lady, my lord, and we have a children, my lord, having a family, my lord.
And this is a revision petition. There is concurrent finding of two courts. What is the error?
My lord, only facts is that, my lord, so far the appellate court is concerned, my lord, that
Hmm.
is admitted that she eloped with the boy, my lord. But only thing is that,
Minor.
my lord, only thing is that minor, but so far my respectable submission before, some of the catching of the judgments are there, my lord. If your lordship consider, my lord,
Give me.
that the age of the victim girl at the time of the examination by the person who has examined the victim girl, my lord, she stated on my lordship may kindly see. in
I'm
the
sorry, that is not the doctor who had come, is not the doctor who had examined.
Yes.
Yes, my lord.
It was examined by somebody else.
That is, we have put that suggestion, my lord, that you have not examined. So my respectable submission before your lordship, my lord, that has to be examined, my lord. When the difference between opinions are come out, my lord, the person who has examined the victim girl has to be examined by the Lane trial court below, my lord. Prosecution has to examine, my lord, so that the conclusive evidence will come out, my lord. Whether she is actually 14 to 16 or 16 to 18, my lord. And if your lordship consider that 16 to 18, my lord, your lordship is very well conversant with the judgments of the Honorable Apex Court, the fraction of the 2 years are to be considered, my lord.
I can consider it in the lower side also. I can consider it in the lower side also.
My lord, so for some our judgments are there, my lord, in our High Court, my lord.
You show me.
My lord.
Incident is of 9,
In
2000.
my lord, 9
My lord, already he suffered, my lord. Already.
May.
My lord, nothing is left for further argument in this case, my lord. Only matter is that whether she is minor or not. Because so far the consent part is concerned, my lord, Learned Appellate Court has also considered that there is a absolutely no doubt there is a consent, my lord.
Where? Where is that finding?
That is, your lordship may kindly see the judgment of the Appellate Court, my lord.
Hmm.
Learned Appellate Court, your lordship may kindly. I have annexed the copy in my.
You go ahead. Show
Yeah, my
me.
lord.
Hmm.
Lordship, your lordship may find. At page 33 of my appeal revision memo, my lord.
Hmm.
My lord, on proper page 30,
Hmm.
my lord.
Hmm.
Second paragraph, on proper scrutiny of the evidence on record, it appears that although the alleged occurrence of kidnapping as stated by the PW3 is not free from doubt, free from doubt and
Read
can,
the,
and cannot be said that the victim was taken by force. Fact remains that she was a minor and a school-going student at the relevant time of hence her consent is immaterial because the consent of minor is no although she was a consenting party, she was at the relevant time under the age of 18. Consent is there, my lord, admitted by the appellate court. Man, only facts is that your lordship will consider the age of the victim girl, my lord. My respectable submission before your lordship, my lord. So for the ascertainment of the age is concerned, my lord, the parents has not submitted any school certificate, any birth certificate. Neither she stated that she is a school-going student, my lord. No document has been supported in purporting to that, my lord. Only thing is that, and that to lordship, with all respect, my lord, that so far the medical opinion is concerned, two opinions came out, my lord. And so the person who has examined, she has also stated that, that at the time of the examination of the girl, my lord, the girl has stated before the person who has examined the victim girl that they were eloped, have love affairs and eloped voluntarily, my lord. In the medical report itself is there, my lord. So there is a doubt, my lord, regarding that aspect, my lord.
no, the age, I'm sorry, but the age, the materials here, I cannot come to a conclusion that she is above 18. And the learned appellate court had also held that she is below 18. So if that be so, the consent goes for a 6.
Immaterial, my lord. My only respectable submission before your lordship, my lord, which two opinions are come out, my lord. The opportunity has to be given to the other side, my lord, so that the person who has examined the victim girl has not been examined by the learned court below, my lord, prosecution side, my lord. Categorically says, my lord, lordship, she went with the boy, my lord, and during the traveling, my lord, she did not raise any alarm.
Mr. Soma, all said and done, consent seems to be there, but the girl is a minor. So that consent is immaterial. Incident is of around now 10, 15, 16 years. We are maintaining the conviction, but we are giving him probation, but you will deposit the fine amount.
My lord.
And my lord, kindly see my lord, the state, my lord, deposition of my lord PW to my lord sister. That in her deposition also, my lord, that she's a school going student, my lord.
No, no, PW2's deposition is that she gave him 20 rupees
Yes.
to buy Singra.
Sing, my lord.
Singra was handed over, that job was handed over to the accused.
To the victim.
And the accused came back and he took the, but there is no allegation of any misdeed done by the girl.
Yes, my lord. That is
That
only.
is the only thing is that 365 is
Yes,
proved.
yes.
So probation,
Fine.
but you will deposit the fine within 1 month. You will go and appear
My lord,
before.
can it be a 2-month, my lord, because I have not got the contact of my client.
Okay,
So I will
2
write a
months.
letter, my
2
lord, to him,
months.
my lord.
2 months.
2 months. My lord.
Okay. Yeah, Louis,
Deeply obliged, my lord. Highly obliged, my lord.
so there was no requirement for any adjournment.
No, my lord. Sorry, my lord.
Ulu Devi, yeah, 125. 16, huh? You are appearing for?
Respondent.
No. Actually, Miss D. Borgohai was appearing in the matter. She passed away. So they have asked for an accommodation. So, kite disoy to? 2810, Mr. Bhatt. 10. Tuesday. Any problem? Have it. What is there? Because I know the advocate passed away, so I don't want to put him into trouble. Let him make some alternative arrangements. The only thing is whether 138 can be maintainable in this case. In your case, the thing is that it is not maintainable. The trial court held it was maintainable, but the I don't know whether that
Because of the, not that it is a company, corporation, but it is a private company.
company.
Private
But there is one evidence available on record about the company secretary being authorized by the board and the company secretary authorizing that second person.
Second person.
Uh,
But the question is that my Apex could have said, court resolution is a must.
That board resolution unfortunately was
was
not,
not done.
or
Not
the
placed.
appellant was not
They have
reflected, was
not placed it.
exhibited.
Yes. On that ground, our district judge has acquitted the
Executed the petition.
person. That the Supreme Court judgment.
So I would like assistance from you on this point because I'm not very sanguine with it.
There's a number of decisions, my lord, that
The relevant decisions you can give
there,
me.
my lord, Kingston's, that it is mandatory. Whenever if a private company comes, AC Narayan case is there, the person who has subsequently come, he must see the transaction. He has not seen the transaction.
No, it's not seen.
That is also there, my lord.
You can just give me a few decisions.
My lord, I have with me, I'll give it. Right now.
Next time I'll come prepared. Or just give the citations, that'll do. Can ask your junior to just write down the citations. This is for the benefit of the court. Yes, Ms. Mondo, come here. You are appointed amicus curiae in this matter. Read the brief, 2 o'clock, we'll take it up. One more is required, no? There is a wife also. So for the husband, who will do? The Tiwari is busy. Who will volunteer? 2 o'clock, husband. Mr. Soikia. Just check up. Read both of you. Facts is like this, I'll tell you. The wife instituted an case under 125 seeking maintenance from the husband. That was allowed, 800 rupees was given. But the plea taken therein was that the wife had left the residence of the husband around 12-13 years back, along with her son. She says that she was forcefully evicted. In the meantime, he fell down. He had injured himself, he is bedridden. There was an agreement by the villagers wherein the husband said that a plot of land would be given in the same homestead, wherein the wife would build a house and stay. She will not claim any maintenance. But the 800 rupees was given. Against that, she went up before the husband went up on appeal. The appellate court discussed everything, found that the case is covered under 125(4), rejected the application filed before the order of the learned trial court, as well as the application file holding that she is not entitled. This is the facts of the case. Just go through that. 2 o'clock we'll take up.
Against concurrent finding, Lordship.
Yes. 326, 341. Yes, Ms. Begum. What do you say? Yes, Mr. Goswami.
As per the evidence, my lord. 5 is the victim, my lord. Identified the victim.
PW5 victim, family members standing in the fringe watching. They were not in a position to come in because
That
of
pretend
the-
not to come, my lord. And all the injuries, my lord, specifically leg,
and
back,
that is by the medical evidence proved.
leg, back, right hand, and also, my lord, on the one leg, my lord, he was hit by the bamboo that resulted into fracture. That is also corroborated.
2 co-accused who were instigating, allegedly instigating, they have been,
They were, my lord, acquitted.
they were acquitted. Because restraint was not there. Yes.
Lordship, page number 8, trial court judgment, Lordship.
Hmm.
That is the prosecution story, Lordship.
This
From the
first
third line,
paragraph,
Lordship.
there is some typographical error.
Maybe another fact inserted in this.
No, that some other thing has come in, but that is clear from the, when the trial court is discussing the evidences, the correct facts have come out.
And Lord, kindly turn page 12, Lordship, the
Hmm.
trial court judgment.
Hmm.
Here in this case, Lordship, PW5, the victim, has stated that the witnessed by Puna Bora, Manoj Bora, and Kani.
Well, maybe they have not
Lordship,
examined.
But the Puna Bora, who is the PW6, Lordship,
Hmm.
but he stated that he never seen, heard it from his sibling, Lordship.
Man
Lordship,
is
Lordship.
being put to such trouble. He can make some statements. He can always make.
And Lordship,
You have the statement evidence of PW6.
PW6, Lordship.
Read PW6.
Lordship.
Hmm.
To read, Lordship, আসামীজনক মই
চিনি
চিনি
পাওঁ।
পাইছো।
Hmm.
গুচৰীয়াকো মই চিনি পাওঁ। মই এই গোচৰৰ ঘটনাৰ বিষয়ে নাজানো। মই
Oman,
ঘটনাৰ দিনা ৰাতি, perhaps 9
Rati,
PM, Lordship,
9 PM.
কামৰ পৰা আহি আসামীগণ আৰু চেনিৰাম বৰাৰ মাজত কাজিয়া হৈছিল বুলি মই মোৰ ল'ৰা-ছোৱালীৰ সতে কয়। Difficult to read, Lordship.
Fine.
কিন্তু যি হৈছিল মই নাজানো। পুলিচে মোক এই ঘটনাৰ বিষয়ে একো সোধা নাই।
X cross.
আসামী কেকন বৰাৰ খুৰাক হয়। আসামী কেকন বৰাৰ খুৰাক হয় চেনিৰাম বৰা। ৰিলেটিভ ফেমিলি, Lordship. কেকনৰ দেউতাকৰ মৃত্যু হয় তেওঁ সৰু থাকোঁতে। কেকন বৰাৰ মাকজনী আকৰি হয়। চেনিৰাম বৰাই আগতে পুলিচত চাকৰি কৰিছিল। চেনিৰাম বৰাই কেকন বৰাৰ দেউতাকৰ মাটি দখল কৰি আছে নে নাই মই নাজানো। আৰু তেওঁলোকৰ খেতি বাতিৰ কথা মই নাজানো। Lordship, perhaps চেনিৰাম বৰাই পুলিচত চাকৰি কৰি আহি খেতি বাতি কৰিছিল সকলো মাটিতে। লগতে কেকন বৰাৰ মাটিতো খেতি কৰিছিল। কেকন বৰাৰ সৰু জুপুৰি ঘৰ এটা বসবাস কৰিছিল আৰু তেওঁ খুজি মাগি খাইছিল। মাক ভিতৰত কি কাজিয়া হৈছিল মই নাজানো। চেনিৰাম বৰাক মই দেখো আৰু ঘোঁৰা পকা আছে নাই।
Yet, my lord,
Difficult to read, Lordship.
the evidence of PW6 Right, my lord.
But
instead
he was informed about it
informed
by the
and
children.
also what comes out, my lord, the motive behind that.
There is there is other evidence also, which says that the accused had misappropriated the
Yes.
MSCT amount of the father
Yes.
of the,
And that-
DW.
That DW1 also, my lord, the motive
Mm.
is clear, my lord.
They all are relative witness, Lordship. And Lordship, if we going through their Lordship evidence, Lordship, there is animus party, Lordship. Because Lordship, from PW1, Lordship, she clearly stated that due to the case filed by the present petitioner, father, Seniram Bora, victim, Lordship, and her husband were behind behind jail.
there are other
6 months.
criminal cases also pending, lodged against the victim
Lordship.
by this. There seem to be some,
Lordship, there is a animus, Lordship, and Lordship, if there is a animus, Lordship, and their relatives witness statement, Lordship cannot, Lordship. normal.
but see, PW5's evidence is very direct. It's direct evidence.
Right.
So what we can at best do for you,
PW7
considering
also,
the,
my lord, I have
Huh?
a statement, PW7, my lord, he also established.
and the family also.
Lordship, one thing, Lordship, there is a, he said that he got telephone instruction, Lordship, on very that day, Lordship.
15 years.
he-
Okay, done. Convicted, probation. Convicted, but you will be released on probation. Done. After 15 years, those family matters, we need not go into. If it was not for the statement of PW5, I would have given you acquittal considering the other circumstances. But PW5's statement is clearly corroborated by the informant 2 and 3, medical report.
So far, close relative evidence is concerned, Lordship, I have judgment, but Lordship may already,
But
Lordship already.
at
give
that
some
point of
relative-
time, there cannot be others. Okay,
Lordship, oblige.
The submission regarding jail term may be sustained, my lord. Our side, my lord.
okay.
Oblige.
Yeah, probably. But appellate court had made it 324, 1 month.
Better.
An eyewitness is there, Lordship, PW2.
And
Session took place,
Altercation took place, he went, jumped into it,
Lordship,
and then he was attacked,
attack.
the finger
The finger.
injured.
Lordship, Lordship.
petitioners expire, your lordship.
Petition expired. Then nothing is left. Mr. T. Gugui. T. Gugui, learned counsel for the petitioner, submits that during the pendency of the present proceedings, the petitioner had passed on. Do you have a date?
But I have I have not received, but I will send.
Has passed on, has passed away, and accordingly he submits that the present revision petition be closed on having become on being abated. Full stop. Prayer is not objected to by Ms. A. Begum, learned additional public prosecutor appearing for the state. So, in view of the above, the present revision petition stands closed on being abated.
Here, my colleagues has been. A brief, your lordship. So. One day, your lordship, time, your lordship.
It's a clear case. Nothing is there. No materials have been brought on record to show one, that there was no, it was a security check, one, nothing. Two, that there is no debt. You were a fish retailer. Okay, we'll accommodate Mr. Gogoi. Mr. T. Gogoi, Learned Counsel, for the petitioner, praised that the brief has been misplaced and request that the matter be taken up on 27/10/2025 to facilitate him to reconstruct the file. Full stop. Prayer is not objected to by Ms. A. Begum, Learned Additional Public Prosecutor appearing for the state. Accordingly, registry to list this matter again on 27/10/2025. Huh?
Here, just for a minute.
Habla.
Yes, Mr. Alam.
In this, my lord, conviction under section 406, my lord,
Hmm.
counts of
Hmm.
imprisonment and 50,000 of fine for misappropriation of his.
Are you ready to pay that 50,000?
No, my lord.
Then argue.
My lord. Here in this case, my lord, petitioner.
Be aware of one thing. Until and unless you don't show me concurrent findings,
My lord.
until and unless you don't show me a major deficiency here, I'm not going to reappreciate the evidences.
Here in this case, my lord, I'll show your lordship, my lord.
Hmm.
One thing, my lord, where is the entrustment, my lord? Regarding the gold jewelry and HSLC certificate. And search warrant is also with the record, my lord.
What about the gold jewelry?
Secondly, my lord,
Gold jewelry.
gold jewelry, my lord, she has taken away, my lord. Since, my lord, that
Where is that evidence?
My lord, in their evidence, they have, both the pedagogists, my lord, their evidences were not, in, whereas, my lord,
Court issued a search warrant.
my lord,
These materials could not be. So you have misappropriated them.
HSCC certificate already recovered, my lord. And
No, I'm on the gold.
gold is also recovered, my lord.
$7.
This is $3, my lord, and she has taken away along with her. After 7 years later, she has filed the complaint petition, my lord, against me.
To me, where is that evidence?
And evidence, your lordship may have found it page 21 onwards, my lord, in the judgment itself, my lord. Reena Devi, my lord. Reena Devi, who is complainant in this case, reports that she got married to accused the month of April 1985. After the marriage, she went to the house of the accused person. PW and stated that she, as she started her conjugal life with the demanding color TV, scooter, etc. as dowry, but she failed to fulfill the demands of the accused person. PW reports that she, as she failed to fulfill the demands of the accused person started torturing her and also used to report her as she failed to conceive baby. During her stay at the house of the accused person's breast in her body, the accused persons did not. Later, the accused persons left the complainant at her at the Red Cross hospital at Silat. PW stated that the accused persons did not come at the hospital, and she also did father of her father. PW stated that after about 4-5 months later, accused was sent one of her back to his house, but she did not go as she feared more tortured by the accused persons. PW deposed that accused persons had already be for the second time, and from second marriage, male child was stated that she sent her sister to bring her matriculation certificate. Important, my lord. She even did not examine her sister, my lord. Matriculation certificate, but the accused person did not give. Therefore, she did not send the people to bring her other belongings from the house of the accused persons. Later, taken back with the help of search warrant issued by the court. Stated that gold jewelry amounting to 72 lakh house 4 cows, that is the her statement, my lord, which were given as dowry at the time of marriage were not returned by the accused person and also recovered through the search warrant. During cross-examination, PW deposed that she filed in this case, after 7 years of coming from the house of the husband, PW stated that after she came from the house of her husband, she, along with her sister Ibama Singh, went to the house of the accused persons to take back her matriculation, but accused persons did not are the same. PW deposed that she did not made her sister Ibama Singh as witnesses in this night. The suggestion that defense is not no articles as stated by her was given at the time of her marriage. PW further denied the accused person did not miss other articles. PW also denied that she deposed falsely in this case to harass the accused person. PW true, my lord. Where she stated that 4 cows, my lord. Here discrepancies are there, my lord. PW two is her cousin brother, my lord. With a relative, co-villager to the parties in this case, the complainant and the accused one, PW one. The case was filed by the complainant for getting articles given at the time of her marriage from the accused. Complainant received back the about half of the articles given at the time of her marriage, but gold jewelry, furniture, clothes, and 1 cow was not received. List your lordship may kindly. PW to further stated that the articles received back by the complainant from the by him, he had also seen the articles given at the time of marriage of the complainant. During cross-examination, PW2 deposed that complainant is a cousin sister in relation to him. That is related witness, my lord. PW2 stated that at the time of marriage, 1 cow, and PW1, that is the complainant stated gold jewelry, among which gold jewelry, neck, ear, hands, and finger were given was given to the complainant. PW2 stated that at the time of marriage of the accused persons which were given to the marriage of the complainant, that was not executed, my lord. PW2 further stated that they cannot show the said list as the said list was given to the husband of the complainant. Accused persons and brought back the almirah, some clothes, and PW deposed that he never said that the complainant bring back the articles given at the time of marriage. He did not go to the house of the accused, but PW denied that he is deposing falsely and complainant is in him. Para 10, my lord. During arguments, the learner counsel who complained submitted the list of articles given at the time of marriage was very much, and the complaint went to recover the articles from the house of the accused person. But the cows and gold ornaments could not be recovered. The learner was submitted to the accused person at the time of further submitted. The defense also the giving of the cow and gold. Learned counsel submitted were already recovered from the recovered. The defense cannot ask for a list now. On the other hand, the learned defense counsel submitted that there is no prayer under section 406 IPC in the complaint petition. There is no prayer in the complaint petition section 406. He further stated that there is no mention of the articles given at the time of marriage of the complaint. Either separate list was provided of the articles given at the time of marriage. Learned defense counsel submitted that Xerox copy of the list submitted by the complainant side is not exhibited. Further, it is submitted that complainant examined only their side out of 4 listed witnesses. Submitted that not a single family member of the complainant was examined who would have been some of the best witnesses to say as to what are the articles given at the time of the marriage with the complainant. Further, the sister of the complainant who was sent to bring the matriculation certificate, namely Ibama Singh, was not examined. It is also submitted that PW2 did not about the articles in his evidence. It is further argued that even if the sake of the argument, Xerox copy of the list of article is accepted, it is not known as to who wrote down the list, as there was no mention of the hubs. Accordingly, the learned defense either. One thing, my lord, her sister is not examined. None of the and she failed to provide the list and who subscribed the list, my lord. That was all. But the articles were already seized by the police, my lord. And learned session judge. This 406 is starting the entrustment in of the articles, my lord. That is absent in the entire judgment, my lord. Since my lord learners to held that at page 25, in the instant case complaint firstly and some of her relatives to bring her accused declined. Again, complaint along with her sister Ibama went to the house. That is the Ibama. Ibama was not examined, my lord. To the house of the accused, demanded a birth certificate to the matriculation certificate, which was also thus offense of impropriety lying the trust to the accused was committed. How it is committed, my lord? I am not on the domain of the articles, my lord. Regarding diagram, the complaint is also rejected by the magistrate, my lord.
Ms. Bora. All said and done. Something is there that some materials were given as freedom. And PW2 also says that these were the materials which were given. First approach made for matriculation certificate only. That was denied. Then she comes up to the court, a search warrant is taken out, and some articles are recovered. But exactly as to what are the items she had taken, because she says 4, the PWT says 1 cow, gold also there is a confusion. Without that, forget the entrustment part. Once the freedom is taken and kept, that cannot be kept under lock and key. It will be in the common use of all the family members. So if the girl is ousted from the house, if the wife is ousted from the house, the husband can be said to have dominion over the property. So that is the, but exactly what is the property in issue now?
Their case, they have failed to
Examine anybody.
evidence to theirs in support of their case, lordship. W1 is the main. As per her version, lordship, some demand. Sorry,
That is not a
that is
case
there.
here. This is
It's there.
406.
Yes, that is their lordship because demand
498A is not coming in here.
articles.
Hmm.
By way of Sridhan, that articles were given at the time of the marriage. That is an admitted fact, and it has failed to cross-examine to that regard.
Let us see the evidence of PW1.
First, my lord, another thing, my lord, your lordship may also produce the complaint.
No, you read. No problem. You read.
From the, yes, lordship.
What does PW1 say? The cross part. She says about the Stridhan article she took in her chief.
In defense, lordship, they failed to demolish the 11 point.
No, during her PW1 during her deposition, she gave the articles which she had taken.
Yes.
Right.
Some of the articles has been taken,
Ah.
but as regard
Gold
to the
jewelry amounting to 7 tola, weaving material, and 4 cows. But cow.
cow,
cow,
Suppose one cow.
one cow.
So that has not been.
And what is the cross evidence in cross?
One as it.
I think this is the case where I could not find the depositions.
Cross part.
Mm.
Lordship, I'll try to read.
Give it to Mr. Alam. Mr. Alam will try. You read in Bengali, no problem. You read it in Bengali.
মকদ্দমা আমি আমার স্বামীর বাসা
You take it to your side and then read.
মকদ্দমা আমি আমার স্বামী বাসা পাওয়ার 7 মাস পরে দায়ের করি। That is after 7 months. আমি মকদ্দমার নালিশে দায়ের সময় আমার বাবা
Read an articles.
আমি আমার নালিশা দরখাস্ত that she has not mentioned.
You read, just read. I can understand. You just read.
আমি আজকে আদালতে আমার বিবাহের সময় বা জিনিসপত্রাদি তার মতো কোনো কাগজ আমি আমার স্বামীর বাড়ি হইতে আসার পর আমার বোন পাস সার্টিফিকেট আনিতে গেলে বিবাদী উক্ত আমি আমার উক্ত বিবাদীর নিকট আমি আমার মেট্রিকের সার্টিফিকেট আমার স্কুল কর্তৃপক্ষ আমাকে নেওয়ার জন্য আমি বিবাদীর বিরুদ্ধে বিবাদী আমাকে নির্যাতন করা আমি আমার বোন ইমামা সিংহকে আমার নালিশে উল্লেখ
So that statement with regard to 7 tolas of gold that she deposed, that has not been demolished. Not even a suggestion to that effect. Forget the cow, forget the wearing materials. But what about 7 tolas of gold? And that is now reiterated by PW2.
that part, my lord, regarding the gold on a
Why? You have not asked her, why should she mention it's there in her chief?
because my lord,
Mr. Alam,
my lord,
let us give it a closure. We'll stick to that 50,000, pay it, clear it off. The other part, jail part, I'll take care. Today, 2 o'clock. Can't help it. Can't help it, Mr. No. These things will not. Otherwise, the jail term will come in your favor.
but misappropriation, my lord, is not.
Arre, that
true.
is their dominion is on you. The
My lord,
domin you
because, my lord,
see.
while-
In Sridhan, you go through the decisions of the Supreme Court, you will get it. Sridhan, it's not the entrustment. It is the dominion which it comes to you, the husband, because it is brought here. You see that definition of 406, see the provision of 406.
Yes, my lord, Hindu Succession Act, I rely section 14, my lord, regarding Stridon, my lord.
What is there?
The property of a female Hindu to be her absolute property.
Absolute property,
Exactly,
right?
my lord.
But
And
this is,
property any,
Mr. Alam, when it comes, when the 406 will come in, this property is not taken. The cow, she is not binding a, she is not taking it with her everywhere. The chairs, a bed that I brought are not taken by her, used by her alone. It is used by everybody. Once she is ousted from the house, who has dominion over the property? The husband. The husband will have dominion over the property.
for as gold part, my lord, normally women.
No,
They
but
will- they
where
will
have you
take-
shown?
they will-
Arey, where have you shown even a suggestion that you have taken the gold with you? We can't presume something beyond evidence.
That part I will acknowledge, my lord, but so far as
That is enough.
she failed to establish that fact that.
Mr. Alam, forget everything. PW1 and PW2, at least it is there. $7 of gold was given, which was not recovered. And there is nothing brought on material. You could have examined somebody, your family members, that when she went with the $7 of gold. $7 is nothing. It can be worn and gone. It can be worn and gone. It's not that it will have to carry it in a suitcase. $7 is nothing. So it can be just worn and gone. So you could have adduced some evidence on that line. You have not done it. 50,000 I think that'll maintain. We'll not give you the, what do you call that,
My lord, tomorrow, my lord, I will satisfy you.
today, 2 o'clock.
Lordship.
At 2, my lord,
No, you need not be here.
my lord, at 2, my lord, I have a fixed matter.
Okay.
Court number 9.
I'll do one thing.
Tomorrow is the first.
It is, we'll only limit it to fine. We are not limiting it to, it is with imprisonment or with
Fine.
fine or both. We will limit it to fine. So we don't want your, right?
Only to that extent, my lord.
Only to that extent. No imprisonment. And
Uh,
this is a case, Mr. Alam, it's a concurrent findings by 2
That's true, my lord.
disposed of.
Only to, my lord, fine.
Only to fine.
Because since he will be retired from service,
That we don't know. We'll only limit it to fine. That's all.
may please. Judgment of Joseph signed in violative of Article 15. So, my lord, this.
Yes, madam, what do you say? 497 Joseph Shine. Who has gone through it? Your party. State
Party is made later on by hand, my lord,
by hand.
as per the order of the court, my lord.
They
23.
should have been the main party here. It's a prosecution by the state.
That's why, my lord.
His lordship.
It's a case wherein the wife, husband was the army officer, army employee, army personnel. So she developed some affection with her brother-in-law, and they started living together. This continued. Then there was village meetings wherein this was directed to be separated. Family, the children gone because of this. PW2 has also, the son has also adduced evidence wherein he has brought on record his mother's thing. Now 497, conviction. Then he says that this will not be maintainable because adultery now under 496. Just show me that. Very good. But will this be applicable here? Will Joseph Shine come here? Joseph Shine is in a different context. No, adultery is not there. This is a different, 497 was set aside.
Yes, my lord, extract of my lord, being positive. Lying on.
Bora, if 497 has been struck down, once it is declared to be violative of 14, 15 and 16,
Yes,
it will go back. Because that prospective overruling has not been made here. If prospective overruling has not been made, it will go to the date when the provision was enacted. We'll have it on Friday. Let me also give it a. But the Learned Council for the parties at length registered to list this matter again on Friday, for further hearing. You can take this back. It by slip query by Muk Birospotibar declare. Kali declare. Yes. You have serious objection in adjournment of the matter. I know that. Now what do you do? Ms. M. Begum, Learned Counsel, appearing for
Ed Kamal.
Z. Kamal, Learned Senior Counsel, submits that the brief in the matter having been misplaced, she be granted a week's time to reconstruct the brief and make submissions in the matter. For this court reluctantly allows the matter being of 2014, this court reluctantly accepts the submission of prayer of Ms. M. Begum and directs that the matter be listed again on 29/10/2025. Also, no further adjournment shall be granted in the matter. Registered to list this matter again on 29/10/2025. Yes, what is the development?
My lord, we are concerned, my lord, and inform the order of the court.
Sir, Upamanya, have they come before you? Why?
They were not there on 5th. Mother has gone to the OC, Koregaon OC,
I said the SP.
but she is not able to.
Then
there,
what
my
did the OC do?
OC has said that I cannot do, he has to do it, SP has to give me order.
Naturally, because the order is for the SP.
Yes, but SP has not passed, not given any direction to the OC concern. And number two, the order was also passed to the public prosecutor, transmit to the SP.
Mr. Registry to heard the learned counsel for the parties, registry to push up Mr. MP Goswami, learned additional public prosecutor shall receive instructions from the superintendent of police. It is Morigaon. Morigaon, as to the manner in which as to the steps taken by him for compliance of the directions passed by this court-wide order dated 15/9/2025. Registry to list this matter again on 30/10/2025. You just get the SP on board. We'll just have the SP on board. And then we'll fix a date. On that day, we'll be taken. And have they met? The daughter and the father have met? Why?
My lord, my instruction is this, the mother says the daughter is welcome to the house also, because that may improve the father's condition also.
I have
And
permitted.
also, my lord, he is communicating, my lord, the petitioner is communicating with her, with their daughter, my lord, by WhatsApp, my lord.
Go meet her.
But there is none, my lord, to take her, my lord. As my lord, her grandmother is now, my lord, is bedridden. We'll take her to Morigaon, my lord.
Okay, we'll do it like this. She has somebody, we will, when he comes to the medical college, we'll arrange for a meeting there.
Yes, my lord. That is
So get the SP on board. Huh?
fine, my lord.
And take an assurance from him that we will fix a date, which will be communicated to him through you. On that day, he will ensure the presence of the petitioner before the medical board. Mr. Bhuyan, keep that thing on hold till the next day. Because can't help it. We'll have to somehow bring him there.
Yes, yes.
Okay, done.
We agree to anything, my lord. That matter should be amicably settled, that's purpose.
Okay, done.
This is the criminal LP for filing a appeal against the order of the acquittal.
Why should we allow this? What is your ground?
Actually, Delhi Magistrate Court already convicted him for the 3 months jails.
Hmm.
But when they approached to the appellate authority, the appellate.
What is the error in the appellate court's order?
Yes, my lord. Annexure 4, page 43.
Why this case was not being pursued diligently from 2014?
But it is number of time it was listed, but the respondent was not appeared.
No, it was, I find a big gap from 20 to 25. The matter was never listed.
Yes, my lord. It's not.
And you have not taken any steps for listing this matter also.
My lord, nobody was appearing in the year 2020 also. Lozima court's order was there. And accordingly, I have taken steps. And from the.
Okay, what is the ground?
Because my lord, in the.
What is that error so palpable that
Yes.
it would require
In
an
my-
consideration?
This is the leave petition under section 378 for granting, allowing the court to hear the appeal. My lord.
I'll have to go into the merits. I can look into the merits also.
Go to the appeal, my lord.
Anyway.
Appeals grounds I have taken the page 3 of my memo of appeal. For the impugned judgment of London Court of Session Judge, Para 1. Guwahati in the short, it is not according to law, facts inasmuch the same has been passed in violation of the observation aforesaid judgment order dated 23/12/2013, provision of section 3A of the Railway Property Unlawful Possession Act 1966, and without appreciating the prosecution report and 16 numbers of prosecution witness. The main. So, as per the Railway Magistrate Court or judgment dated 23/12/2013, he has been, as per the prosecution witness court, he has been convicted under section 3 of Unlawful Possession Act, my lord. But the background 6. Or the learned court below failed to appreciate that in the instant case, 16 numbers of prosecution witnesses who were examined in order to establish the charge under section 3A of the Act, and the respondent number 1 DW also was examined. But for the learned court below failed to take into consideration of the evidence on record and other documents and application of law,
No.
for that the
Okay.
prosecution has
Appeal.
successfully established the offense
Appeal.
under section 3 of the
Confirm.
Act against the accused persons. Respondent also made observed by the learned court of special railway magistrate Guwahati in judgment order dated 23/12/2013 and convict the accused person, and accordingly under section 3A of the Act and sentence the accused person respondent to undergo simple imprisonment for 3 months. Then, my lord, this is under section under observation made in the judgment and order dated 23/12/2013 by the special railway magistrate. On ground number 10, for that learned court below failed to take into consideration that unlawful properties in question are railway materials which were recovered from the above track of the accused respondent who was chased by the OC with the other staff, Gorchuk police station. The recovered properties are also special kind used to
Madam, the entrustment of property is legal. The accused was, the opposite party was entrusted with the material by the railway officials themselves. The materials were to be taken to Amingaon.
Yes.
However, it went through Boragaon.
Yes.
So therein, the materials were seized, right?
Yes.
And that was seized by the railway, by the police, local police.
Local police.
And then here the entrustment it's not illegal. The entrustment is legal. With regard to the seizure, there is a doubt. Why that doubt will not go to the accused, rightly given by the appellate court? What do you have to say on that?
There's any documentary evidence.
May not be. There is evidence. There is that the evidence of the drivers. So he was to misappropriate that. That is not established.
Yes, yes.
So why should we allow this leave application?
Please approach. As per the decision of this appellate court, this is entrusted by the railway authority. So in this case, it was not stolen by the accused,
No,
but the railway magistrate observed that here it is a stolen property. Railway property is stolen.
that is the error. That was rectified in the appeal. Now, why should we undo that? You show me why should we undo that? What is the material? We'll allow the appeal. We'll allow your leave application.
Order judgment dated 23/12/2013, passed in CR case number. In my
Now, madam, have you seen the section 3 of the Railway Properties Unlawful Possession Act? That act, have you seen provisions of Railway 3? Read it.
section 3, penalty for the unlawful possession of railway property.
Hmm.
Whenever is found or is proved to have been in possession of the railway property, of any railway property reasonably suspected of being stolen or unlawful obtained, shall, unless he proves that railway property comes into his possession lawfully, be punishable.
So, madam, this 3 is only with regard to receipt of property. So, the receipt of property here, your evidence itself, it is legal, lawful. How can the section 3 be attracted in the case of the opposite party?
The railway magistrate attracted under the section 3 of the railway unlawful possession property.
He exceeded his jurisdiction. That was rectified in the appeal.
Well, it is not, he was not convicted under section.
Cannot
3.
be, because 3 ingredients reasonably suspected were stolen, found to be in possession. It cannot be said to be stolen here because the evidence is that it was entrusted to him for transportation
Yes.
in course of official discharge of duties. How can 3 come in, ma'am?
That's also cannot deny in the appellate court by the authority, railway authority also.
And from 2014, this matter is occupying space in our
That
room.
the last occasion I informed that it is not a case, you can withdraw the case.
You withdraw it, we'll allow you. If we have to come in, we'll come in with heavy cost. We'll have to, ma'am. You have wasted the time of the railways have wasted the time of the judicial time here by instituting this frivolous.
I will dismiss this appeal.
No, you withdraw or dismissal, I'll dismiss it. There is no problem, but it will be with cost. Heavy cost. This is frivolous, madam. This should not have been filed. You withdraw it, we'll permit you. It's madam coming, so we don't want to pass a cost. That's all. You decide.
As will be appropriate.
Miss MS, U Chakraborty, learned standing counsel, learned counsel appearing for the appellant.
Your
Senior,
special senior railway counsel.
special senior labor counsel, after attempting to argue the matter, to me at civil LP, criminal LP, 18/2025, attempting to argue the matter at some length, submits that in view of the provisions of sections 3 and the conclusions reached in the matter by the learned appellate court, she be permitted to withdraw the present leave application. Also, in view of the submissions made by Ms. Chakraborty, MS Chakraborty, learned Chakraborty, this court, the submissions made by Ms. MS so-and-so is accepted. The present civil criminal leave petition stands dismissed on withdrawal. So close in view of the order passed hearing, so close. I think give it a closure.
God bless.
Because, madam, section 3 is couched in the language that the very receipt has to be illegal. Then only it will kick in. Anyway, we are freeing you of a matter.
God bless.
Yes.
Can it be on Tuesday, Your Lordship?
2 o'clock. You need not be here. We'll record your name.
Regarding dying.
We will record that. Ekini hol nahi dear. Mara file kini paisa do. Ekini side my dear.
Dear my lord, in item number 10, my lord, kindly my name may be recorded as my lord special PP wildlife, my lord. Not 10.
No, that we'll take up only second half.
Fine.
Because the matter is not taken up.
My lord, my lord.
Mr. Kundu was not there.
Oh, yes.
2 o'clock, miss. 2 o'clock. To the forest office and subsequently forwarded to the court. Thereafter, an offence report for violation of section 9, 27 and 29 of the Wildlife Protection Act 1972 was laid. The learned trial court. The learned SDJM Bizni thereafter committed the case for trial before the Session Judge Bongaigaon. The matter was thereafter transferred to the court of the Additional Session Judge FTC Bongaigaon for disposal. During the trial, a charge under section 51 of the Act of 1972 was framed against the appellant's hearing, and the same, on being read over and explained to them, they having pleaded not guilty and claimed to be trial, a trial ensued. Also, on the prosecution, during the trial, How many witnesses? Examined 4 witnesses. Thereafter, the statement of the appellants herein were recorded under section 313 CRPC. Subpara. On conclusion of the trial, the learned trial court, by judgment and order, judgment dated 5/12/2013, proceeded to convict the petition appellants herein under section 51 of the Act of 1972. So on their such conviction, they were sentenced as noticed herein above. Also, being aggrieved, the appellants had instituted the present proceedings. Mr. A. Kundu, learned counsel for the petition for the appellants, has at the outset submitted that the prosecution during the trial had miserably failed to connect the meat so seized to be one of the animal as mentioned in the schedule to the Act of 1972. He has further submitted that no FSL report was no forensic examination was carried, forensic oblique veterinary, no opinion of an expert, both either forensic expert and a veterinary expert was received by the prosecution with regard to the nature of the meat so seized from the possession of the appellant number 1 from the appellants herein. Also, Mr. Kundu has submitted that before that during the trial, the appellants herein had taken a plea that no meat of deer was seized from their possession. Also, accordingly, he submits Okay.
Now, my lord, to find exhibit 18 also I marked here, my lord, wherein prior to that also, my lord, 20 lakhs was given to the accused persons as overdrawing, and this said was as per the telephonic conversation. My lord, to find a flag mark is there where I have mentioned 18, exhibit 18, my lord. Top of it, my lord.
Got it.
Kindly see this. Prior to this also, my lord, they have over telephonic granted 20. So, my lord, here in this case,
But
also-
this exhibit 18 was not accepted by the witness, to whom it, a divisional manager or somebody.
no, my lord, the 25 lakhs, he says that ki over phone this should not have been. But prior to that, my lord, only since a document was there on record, that is why I'm showing 18th. This is 20 lakh. This is not about this case, my lord. This was a different transaction prior to that, my lord. Since it was seized, my lord, so we relied on this document also. Because the bank slips are there, my lord. Prior to that also, the bank slips are there. Everything was there. And that-
So, exhibit 29 is also there.
yes, my lord. Drawing against collection of
With
check.
reference to the, please note that as per your telephonic advice, we have allowed to draw rupees 30 lakhs
to the above
to
party
the,
against
against collection of checks drawn on a lower
lower.
Circular Road branch.
Circular
Calcutta.
Road Branch, Calcutta.
But
Address
this,
to
you did
divisional
not even
office.
have money there. You did not have even money there.
I just want to place one argument before your lordship. My lord, sometimes what happens, if I send a check to the bank and I don't have any sufficient money, my lord, then I request to the bank to give me an overdrawing. So, my lord, these checks would be of no value because since I don't have the money. So now they have provided me an overdrawing, and that overdrawing
So
is,
that overdrawing, if it was per se,
yes, sir.
a overdrawal, normal business transaction, I would have understood. But this overdrawal is against 25 lakhs check.
That's correct. That is why, my lord, those 5 lakh checks were returned. My lord would kindly find the PW. That is what I'm trying.
PW6.
Yes, my lord.
Mahim
Mohim
Paul.
Pal, my lord, took
Hmm.
the checks and draft because those were sent to them because those were 5 lakh checks. Those were not of 5 lakhs, 20,000, my lord. Because that were returned to the Raj Marketing because the bank sanctioned them the overdrawings, my lord. That is why, my lord, Nikhil Merchant, I'm relying, my lord. Because of this fact, para 21, for a moment, my lord would see. Very
Where is it?
similar.
Just a minute. Exhibit 25. Yes, madam.
Mr. Concerned. Raj Marketing Company Private Limited, pure. And even the settle account number,
No account number is.
no account number. The form of settlement contain proper bank. No seal is there.
But your witnesses have not denied that document.
His bank witness. And he has exhibited those, my lord. From the
It
Jorat
came
branch. my
through
lord.
your witness only.
Exhibit D in Amrit Goswami in his paragraph, cross-examination, he outstanding amount
No.
and he exhibited
Two
exhibit
crores
D.
something.
Had there been settlement, then he would have never
Outstanding would be.
outstanding. But in 13, Virendra Dheer never said that it is settled. He has given opportunity. Sunita Dheer also never said. Had there been any settlement, they could have said. Specific question has been put under section 313.
My
No
lord,
whisper.
that submission which my learned brother colleague is placing was on 16/4/92. 16/4/92, my lord. Kindly see.
Got it. 825. PW6, he received the checks
Yes.
after signing in the ledger. The checks were marked to be sent to Lower Circular Road, Calcutta. And it was purportedly sent by hand through MPOL. But MPOL, neither you nor MPOL,
But whatever explanation, my lord, I'll just place. My explanation is that, my lord, once an overdrawing is there, my lord, those checks cannot be produced there because there a separate check has to be there.
Mister, that is not
Because-
your case projected in the trial.
Somebody has made some mistakes in
No, no,
the
no.
report, my lord.
How can we? Then every criminal case will go for a toss.
Then, my lord,
Margin money should be there, performance guarantee should be there, some collateral security.
those documents, they haven't produced.
Then only.
The CBI has not put on record, those were.
Madam. Mr. Tewari, what is very interesting herein is a charge against the other person, other manager. 120B, corruption, conspiracy, clearly established.
But I am for the individuals, 420 only there for against me, my lord.
I know that.
That is
But
compounded
now,
on
now,
the
now,
Citibank
if that
Bank.
conspiracy cannot be in the mind of the appellant in the other case, there has to be meeting of mind with somebody else also.
That has to
You
come
are
from
the-
record. That has to come from record, my lord. The record did not say, none of the witnesses in the prosecution has stated that there was criminal conspiracy between them.
They never say
and-
criminal conspiracy. No.
Okay, okay. Yes, madam, what do you have to say?
And from exhibit 19, kindly be seen, it is a conversation. I have denied.
That in the evidence also, that is there.
Yes.
19-2,
It is a self-explanatory. To the outstanding,
gross.
right, that there is a no out.
Okay.
Never said that there is any proposal going on to settle also. And if they said that there is a settlement on to admission, El Borua has already given the amount, released the amount, and he has no pecuniary jurisdiction to that effect. It has come in the section. At point of time only back is there. And in with regard to Mr. Bose is.
Branch manager is 5,000. Okay. I'm not rushing into it. Now the new evidence, things that have come, let me also examine.
And
This
Raj
is what,
Mukti-
I'll just point out the relevant parts from all the evidences. Because why I'm saying so is, my lord,
Just reserve it for the next day. Just reserve it for the next day. Let me also once more go through it, then I'll come back. Heard the learned counsel for the parties at length. Hearing remains inconclusive. Registered to list this matter again on 3/11/2025 for further hearing.
deeply obliged, your lordship.
Madam, let me also just go through it. I've got your point. Let me just go through it. He is trying to bring his case within that decision of the Supreme Court. That there was an agreement, there was a settlement. And if there is a settlement, no criminality can be attached. What has happened has happened. We
to the offenses.
go.
But my lord, now these three are only there because all the both the branch managers, they have expired, my lord. So
That-
PC goes
that-
out of,
That does.
That will not.
for them, my lord, PC will come. For them, PC will come, but my
For
lord,
you, PC will not come.
so that is what I'm placing. my
Yours
lord,
only
since
420.
my compromise is with the bank, my lord.
Oh,
I can note of this.
Ms. P. Kakoti, learned counsel for the petitioner, submits that during the pendency of the present proceeding, the petitioner herein had passed away. So, the said position is accepted by the learned counsel, learned standing counsel, CBI, who submits that she has received instructions in this connection from the
I'll submit the verification.
she has received the verification report from the CBI authorities.
already received.
I've got it
The officer has taken.
on basing on the কি লিখিছো? She has received. She has received. Full stop. In view of the above, the present appeal stands abated. Full stop. Accordingly, the appeal stands dismissed on having been
Abated.
abated.
Oblige your lordships.
It is 13. 14 to থাকিব 14 আগৰ 12 to আগৰ order মাৰি দিলে হ'ল Yes, what do you find?
Learned session judge has set aside the judgment and order passed by the JMFC. Section 120.
4.
We read section 125(4). Specifically states that no wife shall be entitled to receive an allowance for maintenance or interim maintenance and expenses of proceeding from her husband under this section if she is living in adultery, or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent. Lordship, none of these grounds
Are fulfilled here.
are fulfilled here, Lordship.
Now, tell me one thing. If she has been residing away from her husband for 12, 13, 14 years, would that not indicate her refusal to stay together in spite of that agreement?
Has been living separately due to her mother has, the petitioner's mother has given evidence that she was being harassed for dowry. That is a sufficient reason for which she was living. Moreover, the husband, he had undergone a second marriage. That is also a sufficient reason.
He denies it. He denies it, but anyway. Okay, got your point. So you mean to say that the trial court was correct in awarding maintenance?
Lordship.
Yes, Mr. Sugir.
Humble submission is that, my lord. As my learned friend draws attention to clause 4 of 125, my lord. The categories has been given adultery without any sufficient reason. If they are living separately by mutual consent. Here, my lord, the petitioner has to, the question of adultery doesn't arise because no one has raised any. But regarding sufficient reason, my lord, the petitioner has to prove before the trial court that she has sufficient reason to stay away from her husband. But material available in the record, it has not shown, my lord, that there is a sufficient ground. Only her mother has adduced that she was treated with cruelty, but which has been denied by the.
But she has
opposite
not
party.
instituted any proceeding under 498A or
Yes, my lord, nothing.
of 398A, anything under this thing. That is
No,
your
any other evidence also adduced, my lord. And my lord, the last one, my lord, living separately by mutual consent also may come here, my lord, because in the year 2010, they have entered into an agreement whereby it was agreed to live separately in his campus, in the campus of the husband, my lord, by constructing separate house, whereby it can be said that the mutual consent is also there. As such, she is not entitled to. Which has been.
There's a consent to live inside the same campus. Vagueness in that agreement also.
vagueness is not there. Her deposition is that she went there in terms of that agreement. He did not allow her to come in.
And otherwise, my lord, estoppel is also come, my lord, as per section 115 of the Evidence Act, my lord, whereby she is staying separately since 17 years. During that period, their daughter has
Got married
got married.
without reference to the husband.
Yes, Your Lordship. Whereby she make understand him that she is not claiming anything from husband, my lord, regarding her daughter also. As such, the wife is not entitled.
Take plea of estoppel. There is no problem.
That is a legal plea that will flow if the material so support. The only thing she can disentitle herself is if it comes between 125.4. Your case is it cannot come within 125.4. The ingredients are not satisfied. So the maintenance must flow to her.
Long period of 7. Factor is to
Whenever it is that
to the points that he never denied that she's
okay.
I like to add one more thing. It is, my lord, subsection 1, where it stated, if any person having sufficient means neglects or refuses to maintain, in a written statement and evidence, the opposite party husband has stated that he has made an accident. From that accident, he suffered injuries, and thereby he is not able to.
That will not be enough.
Some
That will not be enough.
insufficient income regarding
That
that.
is
I am
not enough.
stating that.
If you have 2 hands and 2 legs working, you are bound to maintain your wife. But Ms. D. Mahanta, learned amicus curiae, and Mr. M. Soikia, learned amicus curiae, appearing for the parties on the request of this court. The learned amicus curiae have made their respective submissions. Hearing remains inconclusive. Registry to list this matter again on 29 KT. 3/11/2025 for further hearing. I'll pass the order on that. Because they are all tied up today. Yes, Mr. Abedin, what happened? What brings you here? To a criminal setup. You're observing.
Yes, my lord.
Better.
How can it be
Better.
such a drastic
You
switch
can
off?
switch over.
Is also, I think, your lordship is-
That judgment, I'm sorry, because I don't think so. They are in a position to cope up. Because 21st onwards, the thing is pending. They are all dictated, but they are continuing with the thing. So let's see if I can do it today. To may not be possible. I'll do the needful. Don't worry. I'll dispose of the matter. But today, if possible, because I'm one of my stenos, I'm short today. So there are only 2. So it will not be possible. Let's see what happens. You need not wait. I've heard you. No, nothing more to hear.
Yes,
Not wait.
deeply obliged.
Still next. Lordship.
See, dying declaration is not something that he makes a declaration, next moment he dies. It's not that. In the course,
The courts, your lordship. What are the points to be considered?
what is the judgment you want to rely?
That is it, 23 SSC on 1060, your lord.
20?
3.
SC
1060.
10.
60. One more judgment, Your Lordship, at 2007, 15 SSC 465, Your Lordship.
Mr. T. Gogoi, learned counsel for the appellant, after arguing the matter at some length, has submitted that the matter would now be argued by his senior also, who is, however, engaged or who is, however, on legs in another court. Fosso. In view of the above, he prays that the matter be taken upon when
Next week, any date, Your Lordship, hearing day, Your Lordship.
27/10/2025. No further adjournment would be granted in the matter. Registry to list this matter again on 27/10/2025. Answer.